And that's a 15-year felony. So if you are found guilty by a jury, you can go to prison for up to 15 years. So Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course.
None of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction over you. Still a crime. Still a crime.
But I'm not
still
a
crime.
corporation. I'm a living person.
Yep, and that's why you're standing in front of me. If you were dead, the case.
We're back with another intense courtroom moment. And this one features a sovereign citizen facing some very serious charges, embezzling over $60,000. True to form, he tries to run the standard sovereign citizen playbook. But today's judge isn't having it. In fact, she handles his tactics with a mix of quick wit and zero tolerance. You can tell she's heard every variation of this routine before, and she's not about to let it slow the proceedings. This is one of those hearings where the judge's reactions alone are worth watching. Let's get into it.
Mr. Dagger Margosian, how do you wish to proceed?
Well, Your Honor, I am aware that Mr. Musgrove wants to present information to the court. I'm happy to be standby counsel if he wants to represent himself. Obviously, this court would have to go through the colloquy of that, but obviously it's Mr. Musgrove's legal right to at least ask the court to do that. So I'm here to observe at this point.
All right. So, Mr. Musgrove, when you were at the bench or up at the podium before, you said that you were appearing on behalf of yourself. So, Mr. Musgrove, are you asking to no longer have counsel represent you?
Well, what I'm understanding is that the courts is a private for-profit.
So, Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course.
None of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction over you. So
I tried to file paperwork with the clerk's office ahead of time so that you would have time to review it, and they denied me.
I know what you're talking about. None of that is valid under the law.
Out of all the sovereign citizen claims, the all caps theory has to be one of the strangest. According to them, if their name or the case file is written in uppercase letters, it somehow changes the legal reality of the situation. In practice, it proves nothing, except maybe that they've spent time searching online for loopholes that don't exist. It's the legal equivalent of a magic trick that never works. And while they drag the court through these baseless claims, real cases with real victims get pushed aside. If the end goal is to avoid wasting everyone's time, skipping the hearing altogether would be more effective than this routine.
No.
The Supreme Court says it is.
What does it say it is?
The Supreme Court says that if we were at the age of 18, we were supposed to claim our minor status.
Nope, not valid.
Okay.
So here's what I would say to you. Mr. Dagger Margosian is, like most of our public defenders, exceptional attorneys and very well versed in the law and very experienced. He gives legal advice. You may not like the legal advice, but it's usually good advice. I've never had anyone from the public defender's office not wholeheartedly try to represent their clients. So what you are talking about is not valid, and it is not going to get you out of this case. You're not going to be able to say all those things because it's not valid.
Everyone involved in this court case has a financial interest in the case. I
don't have a financial interest in your case. I get paid by the state of Michigan, whether you plead, whether it gets dismissed. I don't make any money off you. We have budgets. The court system is not a profit generating revenue. We are here to represent people so that people who are charged with crimes are protected. People who are victims of crimes are protected. And that's why we have.
In order for there to be a crime, there has to be a victim. There is no.
Well, there is a victim in this case.
The victim would be the company.
You are charged.
I can't face
Ashley, just hold on. So your crime that you are charged with, which you are innocent as of this time, let me grab the right file, is failure, oh, this is let me see. This is an embezzlement charge. So you are charged in count one with embezzlement 50,000 or more, but less than 100,000. That being an agent, servant, or employee of Hardwoods of Michigan Industries did convert to your own use without the consent of your employer or principal, industrial tools and equipment in the amount of $68,938.40 or money or equipment. And that's a 15-year felony. So if you are found guilty by a jury, you can go to.
Sovereign citizens often push for jury trials, and in theory, that's their right. But in practice, it usually turns into a slow-motion disaster. Once the jurors hear the same circular, nonsensical arguments, they're left wondering if the defendant is simply confused or actively trying to derail the process. Neither impression helps the case. In this instance, if he really does take his chances with a jury, he could be staring down the maximum sentence, possibly the full 15 years. Judges lose patience quickly, but juries aren't much more forgiving when faced with arguments that ignore the law entirely.
Using a computer to commit a crime to facilitate the charge in count one, that carries a maximum penalty of up to 10 years in prison. And the way the statute's set up, I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. So the victim that's alleged in this would be that business.
Right, and I can't face that accuser because that business can't get on the stand for me to ask questions, and a third party.
But their
can't stand
representative
it.
can. Yes, they can. Yes,
They
they
can?
can. Yes, they
Okay.
can. So I have 189,000 of student loan debt that was forgiven to be a lawyer. You do not. And Mr. Dagger Margosian, Mr. Isaac Sneed, all of the attorneys here went to law school to know the law, and their job is to advise you of the law. So
Yeah,
yes, they
they're
can.
going-
Yes,
They're
you
going
can be
by
charged.
everything,
You
all the
can't-
laws and statutes that you guys go by
Are
for
legal.
corporations. They're for fixed.
Still a crime. Still a crime.
But I'm not
Still a
a business
crime.
corporation, I'm a living person.
Yep, and that's why you're
Okay.
standing in front of me. If you were dead, the case would be dismissed.
Yeah, the all caps name is that.
That means nothing. That's not valid. It's
Okay.
not legal.
right.
So do you want to represent yourself or do you want to have an attorney to represent you?
I need some time to think.
Okay, so I'm gonna set this for another pretrial on March 20th at 8:30 in the morning. And Miss Adams, could I get a notice of hearing?
By the end of this hearing, it's clear the defendant has done himself no favors. Every time he speaks, he adds another layer of complication to his own case. Judges generally have little patience for disruptive tactics, and you can see why. In moments like this, the hearing becomes less about the charges and more about untangling irrelevant claims. If he keeps heading down this path, it's not unrealistic to imagine the judge assigning him a near-permanent spot in the courtroom just to deal with the fallout. While this isn't the most extreme sovereign citizen we've seen, it's a textbook case of how their approach backfires. Let me know your thoughts. Was this just another day in sovereign citizen land? Or was there something different about this one?